Without further ado, I'd like to introduce Bernie Resnick and Robert Maxwell. They are our presenters today, both alumni themselves and faculty at Villanova Law. So I'm going to hand it over to you, Bernie. Thanks.
Hi, everybody. I hope you can hear me all right. All right, here we go. Hi, I'm Bernie Resnick, and as Kim said, a proud alum of Villanova Law School from the class of 1986. First of all, before I get started, I just wanted to say a very, very big thank you to Colleen Rogers, to Kim Moore, to Brian Sirac, and to Rita Wall, all from Villanova Law School, who really did a wonderful yeoman work putting this all together and made it so easy for Robert and me to do this for you. We're very proud that so many of you, like over 150 of you, have registered for this. Raises some money for the law school, which we appreciate. And we hope that you learn something and that you enjoy it. Now, this presentation is for lawyers to counsel their clients, but also it's for you to take care of yourselves and your own family. I don't want anyone to be the cobbler's child who's running around with no shoes. So, take this to mind and take it to heart for use personally, as well as to use for your clients. For example, this is this month's issue of the Pennsylvania Lawyer. Okay, it's the September-October edition. There's an article in it called "The Case for Elder Law in Pennsylvania." Get this. Pennsylvania is the fourth oldest state in the number of residents age 65 and older in the Union. And this year, the seniors population of Pennsylvania is 25% larger than it was just 2 years ago. So we are aging, and as we age, so do our clients, and so does the state. So these issues that we're going to discuss today become much more important and much more prevalent with each passing day. What I do for my day job is that I'm a musician and went to law school, so I practice entertainment law. And I teach at Villanova Law School. My wife, Sally Madison, and I, we teach the entertainment law course. And as entertainment lawyers, estate planning is essential for our clients because they have copyrights, they have trademarks, they have intellectual property, they've created name and likeness rights, rights of publicity, and those will exist for decades beyond their lives. And as a result, we are always having to counsel our clients about these issues. So let me share my screen now, and I'll go away and you won't see the picture of Center City, Philadelphia in the snow, and I'll share my screen and show you some slides. Okay, so let's see here. These are some examples. I hope you can all see my screen. If you can't, please just let us know. But these are some examples of some famous entertainers who left a mess behind when they passed away. Let's start with the one on the left. That's Prince Rogers Nelson from Chanhassen, Minnesota, otherwise known as Prince. Prince died in 2016 from an accidental overdose. At the time he passed away, his estate was worth approximately somewhere between $150 and $300 million. But he had no written last will and testament. He had 6 siblings and half-siblings, and to this day, his estate remains unsettled and in litigation. The next one, if you look at the right, that's the famous blues guitarist B.B. King. B.B. King died in 2015. He had had 2 marriages in his life, but no kids with either of his wives. As a matter of fact, he and one of his wives tried to have a baby, and they went for testing, and the doctors told B.B. King he had a rather low sperm count. Nevertheless, despite having difficulty conceiving a child on his own, no less than 15 children came along, and 15 mothers of those children who claimed that B.B. King had fathered those children while he was out on the road having after-concert liaisons with them, with the various groupies. So he had 15 children by 15 different women. He never asked any of them to take any kind of DNA testing. He just accepted them as his own. And when he passed away, he left various and several unclear wills and trusts, all of which are still in litigation 5 years after his passing. Bottom of your screen is Aretha Franklin, the Queen of Soul from Detroit, Michigan. She died a couple of years ago in 2018, again, with no will. She had 4 sons. And then in 2019, a lawyer of hers came forward and disclosed 2 handwritten documents that he had discovered. One of them was a letter from 8 years earlier, from 2010, that was locked in a cabinet that the lawyer had, that had sort of the basics of an estate plan, but no real details. It wasn't a proper will. And also, get this, and they found a 2014, 5 years before or 4 years before she died, a 2014 dated spiral notebook, the kind that you use if you're taking notes in school. And they found it, get this, in the cushions of a sofa at her house. And that spiral notebook purported to have some sort of beginnings of an estate plan. That is still in litigation, the Aretha Franklin estate, over the bequest that she left, in addition to litigating who is going to be her personal representative, her executor. That's a total mess. And then there's Michael Jackson, center of your screen. Michael Jackson, for many, many years, had a lawyer, an entertainment lawyer from California named John Branca, well-known entertainment lawyer. And John had represented Michael during the high points of Michael's career, from his mid-20s until his early 40s. And so John had been with Michael for the Thriller and Bad and Dangerous albums, the Jackson's Victory Tour, etc. But they had parted ways, and Michael had gone on to use other counsel for a number of years. In fact, John Branca hadn't even heard from Michael Jackson in 7 years, when all of a sudden, in 2009, his phone rang, and it was Michael, who said, let's get back together. I'm rehearsing. I'm putting my band back together. I'm going to go out on tour. I'm going to go back out into the public eye and the public ear. And basically, he rehired John to start working for him. But 8 days later, Michael died. And so John frantically searched around his office until he found an old will that Michael had written in 2012, from 2002, 7 years earlier. And that will had never been updated. So 50-year-old Michael Jackson passes away with an old will that was not updated. He was a notorious spendthrift, totally in debt, couldn't control his spending, and then everything broke loose, and there was litigation amongst family members. Other people were coming forward. It was insane for a number of years. John and the other co-executor have done a magnificent job to right that ship over the last 11 years or so, and to turn that from a money-losing proposition to a money-earning estate, but it took a tremendous amount of work for them to do that. So those are examples of the kind of people that can leave a mess, but it's not limited just to entertainers. We as lawyers have to think about the what-ifs in the world. So for example, what if somebody's alive but becomes temporarily unavailable due to a force majeure? Force majeure is a French term for a major force, or what we call an act of God. Okay? So we deal with this a lot in the entertainment business, but in your life this year, all of you and all of us have been forced to endure force majeure. So for example, the Pacific Northwest and Southern California and in Colorado, there have been terrible wildfires that have upset everyone's lives out there. There have been dozens and dozens of named storms, hurricanes and tornadoes. There was a derecho here in suburban Philadelphia in May, which knocked Sally and me out of power, internet, and telephone service for almost 4 days. There's been terrible situations involving civil unrest, riots and looting in West Philadelphia, in Center City, and all over the country. What about the old pandemic? Remember that? The COVID-19 pandemic has caused lots of people to be unavailable. And don't forget, just a few short months ago, there were hundreds of people that were stranded on a cruise ship off of the coast of Washington State, not sure if they could dock. These people were temporarily unavailable, that they might have had business that needed to be taken care of. What if someone's alive but incapacitated? God forbid, they're in an accident and they're in a comatose condition. What would you do? What if someone begins to suffer some dementia, or they're having memory problems temporarily or permanently? How about if someone makes a new business and that business will continue long after they pass away, and they need to pass it on to other family members or other survivors or other business associates? How about if somebody, like I mentioned before, especially in the entertainment business, controls lots of intellectual property that will continue to earn revenue long after the creator passes away? We need to deal with that. And finally, what if someone amasses enough wealth that they go beyond Pennsylvania or New Jersey or Delaware state inheritance tax? Now we're looking at federal United States income tax, that could be significant. So we need to plan for this in these documents. Now, let me talk to you about and remind you of what happened with Terri Schiavo. It was an example of, this type of situation when, someone can accidentally leave behind mess. Miss Schiavo lived in Florida, and in 1990, she suffered a heart attack and was in a comatose condition in the hospital, where she lay in the hospital bed for 15 years. She was in a coma. She had irreversible brain damage. It was a terrible situation. Her husband wanted to terminate the life support, pull the plug, as they say. However, her parents did not want to do that, and Ms. Schiavo had not left anyone any specific written instructions for what happens for her health care were she to be in a comatose condition. If you remember, this became a cause célèbre. The governor of Florida at the time was Jeb Bush, President George W. Bush's brother. He led an effort which eventually got his brother George involved and the United States Congress involved to try to reinsert a feeding tube and to keep her alive. There were people who were having vigils outside of the hospital. It was really crazy. Finally, a local judge allowed the plug to be pulled, and Ms. Schiavo did pass away naturally, but not after tremendous amounts of inter-family strife and lots of litigation. Coach John Wooden of the UCLA basketball team, long before Villanova was a powerhouse. Well, actually, Villanova lost to UCLA when Coach Wooden was coaching in around 1970 in the finals. Coach Wooden had a great expression. Failing to plan is the same as planning to fail. So what we need to do when we're dealing with our own family members, with our own lives and businesses, with our own practices, and with our clients, is we need to make sure that every estate has to have certain documents. You need to think about all these things. So number one, obviously a last will and trust, a written document that's up to date, that's duly signed and notarized with the witnesses, et cetera, complying with the local and state rules and regulations. There's also something called a durable power of attorney. That's a document that gives someone the ability to sign things and make business decisions on behalf of the person granting them the power. Pennsylvania, a year or two ago, enacted specific new rules updating how durable powers of attorney are to be signed and enforced. Then people often forget about beneficiary designations. 401k pension plans and life insurance policies and bank accounts often have beneficiaries. So if the holder of that account passes away, who receives the money? People often forget in situations when their minor child, who was their beneficiary, reaches the age of majority, or when their marriage ends, they forget to update their beneficiary designations. So you always need to constantly take a look to make sure that those designations are accurate, up to date, and the beneficiaries can be found and they're the person you want. Then there's something called a letter of intent. That can be the kind of thing that was in the spiral notebook that Aretha Franklin had underneath the sofa in her living room, in the cushions, or it could be something more detailed, which I'll get into in a few minutes, which is sort of the book that I wrote, the questionnaire called The Big List. We'll talk about that in a few minutes. Another estate the state ought to have is a healthcare power of attorney. That's the document also known as an advanced healthcare directive that Ms. Terri Schiavo from Florida did not have. Hence the legal dispute that arose between her and her family members, her husband and her parents, about whether or not life-saving measures, artificial means could continue to be used. You can designate whether or not you would have a lot or a little of that kind of infiltration into your life and your health. And it's very important to do that, sort of save the heartache of your family members of not knowing what to do and what your wishes are, but also at the same time, give clear instructions to your physicians about what might or might not happen. So for example, do you want your organs donated? Do you want artificial means to be used to keep you alive? Do you want a feeding tube inserted, et cetera, et cetera? You can make all those specific designations in a healthcare power of attorney, and you need to make sure that you're very clear in how you designate that. For example, Sally and I, my wife and I, we both have these, but we have, let's just say, very different opinions about what should or should not be done. So we have slightly different designations in our healthcare power of attorney. Finally, we have to think about guardians. Your client may have minor children who need to be taken care of, or you might have grown-up friends, family members that you need to take care of, and who would be their guardian? So what if someone is autistic? I have a cousin who happens to be in his 60s, and he's severely autistic. And my cousin, his mother, who's in her 90s, it's actually her 93rd birthday today. I called this morning to wish her happy birthday. She's made designations for what happens to my cousin after she passes away, who will be taking care of him. These are the 6 essential documents that work hand in hand. And if you have those organized for your client, then chances are less that you'll leave behind any kind of mess. Now let's talk about the book, The Big List. And let me tell you a couple of stories about that. This is a book that I wrote and published a number of years ago. The main categories in the book, and this is kind of a letter of intent, but a long version of it that's about 75 pages long. Main categories in that book are things like listings of the person's assets and liabilities, listings of their professional advisors, their lawyers, their doctors, their accountants, where you can find those people. What about your spiritual advisors, your reverend, your priest, your rabbi? You would name those so that if need be, your person who's helping you can know to contact those people. We have other liabilities someone might have. What if you've got a business? What are the business assets and liabilities? Do you own any property that you're renting? And what are the details about your tenant, your landlord license, et cetera? About intellectual property. Do you own and control copyrights, trademarks, patents, rights of publicity that you created or that you've purchased? Sally and I have done business with someone who also buys and sells trademarks of businesses from long ago that are now defunct, and then monetizes those trademarks. So you need to tell your survivors what those are and what the details are. You also want to detail your professional licenses. When is your next CLE deadline that you need to do your courses, for example, and who licenses you? Are you just in Pennsylvania as a lawyer, or are you also licensed in the District of Columbia, for example? Then there's other, miscellaneous items such as your digital legacy. What are the passwords for the various websites and social network pages that you use? And, do you want those things to live on after you're gone? So let me tell you the story behind the book. My late father was a doctor at Temple Hospital. He was a surgeon for over 60 years. And at one point late in his life, he took me aside and he told me that he was going to need a big heart operation. And he said that he might die on the operating room table, but if he was fortunate enough to recover, he was going to be laid up for months in intensive care and then in a rehabilitation facility, so he would learn how to walk again, get his strength back, and relearn a lot of basic motor skills and basic occupational therapy. And he was telling me this to prepare me. And I said, listen, Daddy, I don't know anything about doctoring, but I know about lawyering. So what can I do to help you? And I created a questionnaire for him, which he dutifully spent a few hours filling out, with questions like, hey, Dad, where are your car keys? And where do you pay your mortgage payment every month? And where's your checkbook? Where are the deposit slips? When the hospital pays you your salary, do they send you a check in the mail? Does it go automatically into your account? Et cetera, et cetera. And so every few days while he was in the hospital and rehabilitating, I would go to his apartment and I would open the door, go through his mail, pay his bills using the durable power of attorney that I had, going through the list so I knew where to go and what to do. Made arrangements for things like putting a grab bar into his shower so he wouldn't slip and fall when he was recovering and showering and coming home. And when he came home, he walked right back into his life, no pun intended, without skipping a beat. So after this experience and how helpful it was to him, I was telling friends and colleagues about it, and other lawyers would say to me, hey, Bernie, I have a mother who's losing her memory a little bit. Can I borrow that list and get her to fill it out before she forgets everything? Or, hey, Bernie, I have a sister in Colorado who's a bit of a hoarder. I need some help straightening her out. Can I borrow that list? And eventually, lots and lots of people were asking for us, and I decided to publish the list. So that's what this book is. And whether it's my book or other people's books or questionnaires that are similar, it's really helpful to have something like this that goes hand in hand with the other estate planning documents to make your executor's life a lot easier. Another story I want to tell you is that after my late father passed away, Sally and I, my wife and I, went to his apartment, and he had a lifetime's worth of goods and a lifetime worth of documents and papers piled up all over the place, like anyone who's in their late 80s would have. And we couldn't do all this in one day. We would go over for an hour at a time, and we would go through his desk drawer or the pile of papers on the kitchen table, etc. And the moral of the story that I want to impart to you is you need to touch every piece of paper when you're someone's executor or when you're advising someone who's an executor. And the reason is you might find debts that need to be taken care of the deceased or incapacitated person, but you also might find assets. And that's what happened to us. Sally found a couple of things when going through my dad's papers that were very, very useful. First of all, my dad was a great patron of the arts, and she found a pile in his desk drawer of all of his different seasons tickets to the Chamber Music Society, to the orchestra, to the theater, to the ballet, to the opera, this, that, the other. And we were able to give some of those away to family members as gifts in my dad's memory. We were able to turn some in as charitable contributions back to those organizations. She also found a letter from Pennsylvania Blue Shield, because my late father was on the board of directors of Pennsylvania Blue Shield. And the letter said, "Dear Dr. Resnick, thank you again for serving on our board. We'll defer your compensation as you always instruct us to do." And I scratched my head and said, "What's this all about?" And I contacted them, and I found out that there was a substantial amount of money that he had never taken from them. They were just holding for him. And then we were able to receive that into the estate and then use it for bequests that he had left to family members. So it's very, very important that you touch every piece of paper in an estate just to make sure you find all the debts and all the assets. Now, if you have a desire to purchase the big list, in your handout materials, there'll be a link that you can use. It's about $18. I think it's very helpful to me in my life. It's made my life a lot easier. I hope it'll be helpful to you and your clients. If you don't have time to copy this link down, it's fine. Don't worry. In your materials that are being emailed to you, you'll receive this link. I'd be touched if you would make a purchase of a copy. It's my shameless plug. And if not, that's okay. Make sure you have somebody's list that covers all these things so that you can counsel your clients and help yourself to do a better job. Now, we also have the secret CLE word. You need to use this. It's Wildcat, WILDCAT. When you fill out your forms to get your credits after this presentation, please make sure that you remember and write down the secret word for my presentation, Wildcat. When Robert speaks next, he'll have his own secret word, but my word is Wildcat. If you have questions, I'll try to bounce in and say hi in the breakout rooms afterwards, but you can contact me, or you can always contact Kim and Rita and Colleen and Brian from Villanova, and they'll forward your questions to me. I'd be most happy to answer. Now, let me talk to you for a minute. I'm going to stop sharing my screen, and I'll come back to say hello to you. And let's see here. Here I am. Okay, hi. So let me talk to you about my co-panelist, Robert Maxwell. He's also an adjunct professor at Villanova Law School, where he teaches fundamentals of testamentary estate planning. His day job is that Robert is the director of estate and trust settlement at the Glenmead Trust Company. So he handles all aspects of an estate when Glenmead is named as a corporate trustee or executor. Glenmead Trust Company, let me tell you, is an investment management company which serves as a corporate trustee and executor. I have referred clients to them over the years, my 33, 34-year career. They're a fantastic, fabulous company and very, very good at what they do. One of the best in the region. I personally recommend them. I've referred clients to them. I think they're tremendous. It's the same family that is the Pew Charitable Trust in Sunoco, and they're old-time Philadelphia family and company. They're wonderful. Now, let me tell you a fun fact about Robert before I turn it over to him. I was a music and political science major in college before I went to law school. I went to Colgate. Robert went to University of Pennsylvania undergrad. He was an anthropology major, of all things, qualifying him to be a lawyer. In the summer of 1983, Robert was studying in China. He was one of the very first Westerners ever to see in person the tomb of the terracotta warriors in Xi'an, China. For those of you who had a chance to see this exhibit of a small fraction of those warriors at the Franklin Institute last year, it was fabulous. And so one of the very first people to actually see that from the Western world. And with that, I'd like to turn it over to Robert, who will tell you exactly what you do when you have a mess on your hands and how to fix it. Robert, in the words of Ed Sullivan, take it away.
All right, thanks, Bernie, for that kind introduction. Thanks, Villanova, for asking me to join in this presentation. So, as Bernie said, I'm going to talk about the messy side of things here. And this is, of course, the test. If I can start my screen. All right, here we go. So I thought it would be interesting to start with this. So looked on one of the internet sites, and on average, it takes about 570 hours for an executor to settle somebody's estate when they pass away. And a lot of that work is involved in finding assets and liabilities. And as Bernie said, if you have Bernie's book that forces you as a individual to write down the location of your bank accounts, your stock certificates, what debts you have, who your important advisors are, your attorney, your accountant, your stockbroker, that makes the executor's job a lot easier. And hopefully it will take that executor less than 570 hours to handle your estate. But if you leave a mess, it's going to take a lot longer. So some of the important assets to think about: real estate, bank accounts, brokerage accounts, bonds, life insurance, personal property, liabilities, mortgages, credit card bills that an executor has to wrap up when somebody dies, those ongoing utility bills for somebody's house, any notes that they borrowed money, and any lawsuits that they were involved in. So as I said, it's easy if you have a client or you yourself are organized when somebody passes away to go to that list and identify the assets and liabilities that the person had. But if the client never bothered to fill out that list and was completely disorganized, you're left with a mess, and your job is to act as a detective to find those assets and liabilities. So I put in this slide from a TV show from many years ago. There used to be The Odd Couple, where Tony Randall was the neat, organized person, and Jack Klugman was the slob. And I'm going to be dealing with this slob, the messy person, how to deal with their assets. So does this look familiar to anyone? Many years ago, before I went to law school, my dad was an attorney who in his retirement handled estates for individuals. And he had a friend who was in the Roxborough Lodge in Philadelphia who passed away and was asked to handle that person's estate. And this friend lived in a retirement home up on near Germantown Avenue in a 2-bedroom apartment. His only surviving relative was a nephew, and my dad and I went to the funeral along with the nephew and his wife. And after the funeral, we said, well, do you want to go back to the person's apartment and see what was there? And the nephew said, well, I didn't really want to be bothered, don't want to handle looking through the paperwork. So my dad went back, and this is pretty accurate representation of what we found. And we started looking through the papers. As Bernie said, very important to look through the papers of the person's house or apartment. And we found a suitcase that had envelopes in it that were stuffed with $20 bills. And if you look at your old $20 bills, on the $20 bill in a little circle on the right, it would have the mint where that $20 bill was printed. The C was, whatever, Philadelphia Mint, D, Denver Mint. And this person in his retirement had apparently spent hours sorting his $20 bills in these envelopes by the mint where they were printed. And we took the suitcase and some other paperwork home with us and spent the whole weekend counting the $20 bills, and he had over $40,000 in cash in his apartment. So very important to do a physical inspection of the client's apartment, residence, to not only find cash, coins, jewelry, other valuable personal property, but to get copies of their important financial records. If you're not able to find, records about real estate or financial records, there's a couple of ways to think about, to go about finding that information. And in terms of real estate, of course, when you're handling an estate, how a client owns real estate is very important, whether they own it as tenants by right of survivorship or tenants in notarities where it passes to a surviving joint tenant or spouse when they die, or if they own it in their own name where it passes under the terms of their will, or if there are mortgages on the property. So if you're unable to ascertain through the paperwork in the decedent's files or safe deposit box how they own property, one of the things you can do is go to the Recorder of Deeds. Now, a lot of that is online, and just for fun, I decided to run a real estate search in the Recorder of Deeds for Delaware County and found some properties that Villanova had bought from people over the years, some mortgages, and Delaware County allows you to actually click on the link and look at an actual copy of the deed on record. So if you're looking for real estate for a client, the Recorder of Deeds is an important place to go, either virtually in this COVID world or a physical visit to look through the paper records. Another place that typically a deed might be for property would be in a client's safe deposit box. So if you're able to figure out that a client worked or had an account at a specific bank, you can contact that bank, write to the bank, ask them if the client had a safe deposit box, if they're organized and have that information in a book like Bernie's. You can maybe find where that key is or box is. And as executor, you can arrange with the Department of Revenue, sending a notice to the Pennsylvania Department of Revenue, and then arrange with the bank as executor to go and do a safe deposit box inventory, where you actually go through what's in the safe deposit box and you write up a report of what is in there that goes back to the Department of Revenue. And on the bottom of the screen, and these slides will be available afterward, is a link that has some information for executors about access to safe deposit box. But what are some of the typical things that people have in their safe deposit box in addition to deeds are stock certificates, if they're paper stock certificates, coins, jewelry, and life insurance policies. So those are some of the typical things to look for in a safe deposit box. Some clients also have their will in a safe deposit box. So sometimes you run into a conundrum of you need an original will to be appointed as executor of somebody's estate, but you're not appointed to be executor until you have that original will, which is locked away in a safe deposit box. You're allowed to get limited access to a safe deposit box to get an original will. And that's why a lot of attorneys either keep a copy of the original will for their clients or tell their clients to keep it not in a safe deposit box where it's locked up. Another great place to look and try to identify assets that a client had is to look at their personal income tax return. And for New Jersey, any of you that practice law in New Jersey and have done a New Jersey inheritance tax return, New Jersey, when you file a New Jersey inheritance tax return, actually requires the executor, in addition to the will and the inheritance tax form, to submit a copy of the full last year personal income tax return of the client. Why do they do that? Well, we also at Glenmead when we handle an estate, try to obtain the last 3 years of personal income tax returns of the client. And there's a couple of reasons the Department of Revenue and we want that information is, one, when we're handling an estate, the last 3 years of income tax returns are the ones that are subject to audit by the federal government. So we want to get copies of those returns in case they are audited. The second reason that we want them, and the second reason that New Jersey wants a copy of that return, is on your income tax return, right? Think about it, it lists all of your income producing assets. So a great way to identify whether a client had income producing assets and what those assets were. So just looking at the front of this income tax return for Joe Smith, couple of things I can tell in boxes 2A and down. So number one, wages, right? So this person had some kind of wages. So maybe there's something owed by an employer, wages for the last couple of weeks before the person died. Maybe there's some employee benefits, life insurance, or other type of benefits. I can see in line 2 that he had tax exempt interest, so he probably owns some kind of municipal bond or municipal bond funds. He reported 40,000 of qualified dividends, so he had a stock certificates or a brokerage account, and also reported pension and IRA distribution. So I know as my detective job here for somebody that left a mess, I need to try to track down that information. And I flipped to Schedule B of the return that lists interest and dividends and see a couple of things here. So I see that he had a Citizens Bank account. I'm going to write to Citizens Bank, ask for information about the bank account. I might ask, well, hey, did he have a safe deposit box there as well? I see that he reported interest from a Jane Jones promissory note. So I know that Jane Jones owed him money at one point, and gonna have to try to find information about that. And then also see that he had H-bond interest from the Department of Treasury. So the Department of Treasury has a website where you can redeem bonds, get information about value of bonds, and also fill out forms if there are lost bonds to claim the proceeds of those savings bonds. So that's what I can see in terms of interest. In terms of dividend income, well, I see that he reported something from Merck. So he either owned Merck in shares outright or maybe online through some online brokerage. I see that he had a Janney brokerage account, so I'm going to contact Janney. And I see that he reported dividend interest from a trust under the will of June Smith. So I'm going to need to track down that information as well. At the bottom of Schedule B of the return is this kind of innocuous question. Did the person, Joe Smith, have any interest or signing authority over a financial account that was a foreign account? And here that box is checked yes. So I'm going to need to track down, did he have some kind of a foreign bank account, maybe a UBS, Bank of Switzerland account, or some other kind of foreign bank account? I'm going to need to track that information down. Another thing to think about as executor is forwarding the mail. What do you get, what the clients receive in the mail? Those of us that still get paper statements and paper bills and are not completely digital, is you get your bank account statement, your brokerage account statement, information on stocks that you receive, checks, and also all of those lovely credit card and utility bills in the mail. So as executor, you can file a mail forwarding address to have the decedent's mail forwarded to you, and you can monitor it for that particular information as long as you give to the Postal Service a copy of your short certificate from Pennsylvania that proves that you were appointed as executor. So Typical things, as I said, you would get in the mail, brokerage and bank account statements, as well as credit card bills, utility bills, and you can monitor them and pay them through mail forwarding. Another thing for somebody who leaves their estate in a mess is to check the Bureau of Unclaimed Property. So if the client, and you can do this for yourself because you might have some out there as well, if you go to the PA Department of Revenue has a Bureau of Unclaimed Property website, and you can search for unclaimed property. So what is unclaimed property, right? So if, somebody mails a check to Villanova, it goes to an office, the person doesn't cash it, that uncashed check after a certain time period, the money that's never cashed escheats to the state and goes into this unclaimed property bin at the Pennsylvania Department of Revenue. So I just did a search for Villanova University, and it has some claims here, Amazon, Carolina Biological, over $100, under $100. If you click on that claim, it gives you more information about that piece of unclaimed property, what it's worth, and you can fill out a form as the executor, or if it's, if you do it for yourself as a living person, you can fill out that form, send it into the Department of Revenue, and get that money back from the Unclaimed Property Bureau of the Department of Revenue. So that's all good for clients that are living in a paper world, but as everyone knows, 75% of people have some digital presence, or 100%, probably 100% of people have some access to digital assets, email accounts, Facebook, other information. So the Pennsylvania this year passed its version of the revised Uniform Fiduciary Access to Digital Assets Act. So say that 3 times fast. The short word for it is RUFADAA. It's effective starting next year, and it applies to how does an executor, an agent under a power of attorney, a guardian of a client, or a trustee of a client gain access to digital assets that the client owns. So there you'll see the CLE word for today. My part of this is digital. And under this act, there are some key terms to think about. And digital asset has a kind of a broad meaning, electronic record in which an individual has a right or an interest. I'm going to be primarily focusing on emails. So when I'm talking about digital assets, I'm really focusing on the client's emails. And under this RUFADAA Act, there's an important distinction to keep in mind between the difference between what's the catalog of electronic communications and the content of electronic communications. So think of the catalog when you get a letter in the mail. The catalog is the outside of the envelope, right? Is the address and the date it was mailed to you with a postmark. So the catalog is the outside of the envelope. The content is what is inside that envelope. So think about your physical mail that you get every day. And when that gets forwarded to an executor after you die, what do you want them to read in terms of the catalog or the content? And here we're talking about emails. We're not talking about physical mail. So the catalog is really that list of emails that you got, who you received them from, and the date and time that you received them. So the catalog, an example of the catalog would be, Bank of America, title, statement ready, December 9th, 2020. that would be the catalog. But the content would be inside that, what the text of that email is. So it might have a copy of the bank statement, a link to the bank, a copy of the statement itself. And the presumption of the federal law and this RUFADAA, the state law, and a lot of other states have this version similar to RUFADAA, is that most people are fine with their executor or their fiduciary getting a list of their emails and who they came from, the catalog, but not everybody is probably fine with that executor reading the content of those emails. So think about the emails that you get each day. If it's from a bank, maybe you're fine with your executor looking at the content of that email. But if it's from a friend or a relative or some very personal, deep note email, the client might not want the executor to read that. And that really, that love letter email might not be really necessary for estate administration. So how does an executor get access to that catalog or the content of somebody's email? The first priority under the RUFADAA is what's called an online tool. So an online tool is something under a internet service, like, and Google and Facebook are really the primary ones that have these online tools, where you can specify what happens to your account when you pass away and who has access to it and what they have access to it. So I'm sure 99% of you have Gmail, and here's their online tool. It says, if you go to privacy and personalization, I encourage you to do this after our seminar today. You can fill out the online tool. You can decide down here at the bottom when your account becomes inactive. So I have mine set that after 3 months that I haven't used it, it becomes inactive. And then they send me an email saying, hey, this is about to go on inactive status. And if I'm dead, unless I have magic powers, I'm not responding. And then this inactive account manager kicks in, and I can set up 10 people that will get notice when I die or when my account goes inactive, and they have access to a certain amount of my data. So important thing to think about for all of you that have Facebook and Google, which is probably 99% of you, is to look at the online tool that those web providers have and set up what you want to have happen to your account when you pass away or it becomes inactive. You can also decide with your Google account if it gets deleted after it becomes inactive for a certain amount of time and nobody has access to it. So I don't have that feature set up, but that might be important to you. The second place under the RUFADAA to look is somebody authorized in an estate planning documents. And as part of my job in managing estates at Glenmead, I review draft wills that clients write or their attorneys write for them. And I see more and more wills have intricate plans for what the executor has access to in terms of digital assets after somebody dies. So, you know, you should have this, consider this something in your will, power of attorney, or your trust document as to what you want happen to digital assets, what you want to have your executor to have the power to deal with afterward. Here's a sample will clause. I have a link to this. This is kind of a broad sample will clause. It says my executor has the power to have access to the catalog and the content of all electronic communications of mine. So here he can read my love letter emails that I got, but you know, you or your client may want to specify they only want to have certain levels of access, only the catalog and not the contents of the emails. The third place to look is the terms of service agreement. So what's the terms of service agreement? When you download a new program on your phone or on your computer, and makes you scroll through a 10-page agreement, where down at the bottom you click, I read this and I accept this, and then the program installs. That's the terms of service agreement. So if there's something in the terms of service agreement about what happens to the account after you die, that's the third place to look. Now, under the Pennsylvania version of the statute, as I said, it's easier for somebody who's an executor to get access to the catalog of emails. And the custodian, who would be the internet service provider, is authorized under this RUFADAA Act to disclose the catalog, which is the list of who you received emails from and the date those were received, upon a written request of the executor, copy of the death certificate, copy of the letters testamentary, which shows that you were appointed as the executor, information about the account. So you got to tell that Google or Gmail or Facebook that, hey, the client had an account there, and an affidavit signed by the executor that it's reasonably necessary for the administration of the estate to get that catalog information. And as an executor, the catalog is really probably what I'm going to need to know, because I'll see that email from Pico. Your utility bill is due. Comcast, your Comcast bill is due. Bank of America, your statement is ready. Janney, your statement is ready. And I'll be able to send a letter to those individuals to find out about the bill or that particular account. The letters testamentary, the statute requires a finding of the court, and letters testamentary will be kind of presumed as a finding of the court that this is necessary. To get to the content of the emails, it's a little, you need to provide the same information, but also need to provide to the custodian a court finding or order that this disclosure of the content of the emails doesn't violate federal law or the RUFADAA statute, and that your decedent consented to that disclosure. And the best evidence of that is obviously in their will, or maybe in the online tool, or some other written statement that they disclose that information. And you also have to really prove to the court has to find that that disclosure of the content is necessary for administering the estate. So that might be a harder burden in certain circumstances, but it depends on what information you're trying to find. I know that one of the kind of disturbing things when I go on social media is getting contacted, do I want to link with somebody that I know has passed away, or some of those Facebook accounts that are kind of keep on going where the person has passed away. So some social media do have capability to remove a deceased person's account. And I just wanted to highlight this. LinkedIn has a specific page where you can request that a LinkedIn member's account be removed, and you fill out an online form, who the deceased person was, what your relationship to that deceased person is, what the profile for LinkedIn is, and how do you prove that the person has passed away. Do you have some kind of a online obituary that you can share with LinkedIn? I recently went to a seminar. They had a vendors conference, and I wanted to highlight this at the end here. This is an online, it's called EasyNet. There's a link here. This is an online service that does a couple of things to help people, while they're alive, sort out their internet presence as well as after they pass away. So from their website, a couple of statistics here, that the average American has 130 usernames and passwords, 3,700 password reset requests a year, and spend 11 hours resetting your password each year. EasyNet provides a password manager. I know other services, I have Comcast, they have a password manager, Google has one. They have a way you can secure and kind of share up in the cloud important financial and other documents, and also kind of like an online worksheet with important information about assets, liabilities, who your important advisors are, and where certain assets that you happen to be. So another thing to think about is, some of these online services that help you get organized as well. So in summary, as your mom would tell you, time to clean up your room. As Bernie would tell you, time to clean up your act. To prepare for your own estate, prepare your clients, try to get them organized, fill out some kind of a worksheet, use Bernie's book, use some kind of a worksheet that makes that job of the executor much easier, and they'll spend maybe a lot less than 570 hours trying to figure out what you had when you passed away. I'm glad to answer any questions. My contact information is here. My Villanova information and my Glenmead work address are here, and look forward to hearing from you. Thank you.
And Robert, I actually, I have a question for you and for everyone still on. You should have received the CLE evaluation email by now. If you have not, please email myself or Colleen Rogers in the chat box. We will still be doing breakout rooms following the program as well, but I just had a quick question, one for Robert and one for Bernie. Robert, we had someone ask us, what does it mean to probate a will? And is it required if we state in the will that the estate is to be divided among children?
So great question. So what does it mean to probate a will? So in Pennsylvania and in other states, you're taking a copy of the original will to the Register of Wills, and you're swearing as executor that you will serve as executor faithfully. And probate really comes from the Latin word to prove, right? So you're proving that you have the valid original will, that's the last will and testament of the client, and you probate it, you give it to the Register of Wills, they swear you, and then they issue what's called a grant of letters, which is the official Register of Wills approval that you are appointed as executor. And then they also give you short certificates, which are evidence, a one-page evidence that say, Joe Smith died December 9th, Robert Maxwell is the executor of that estate. And when I go around to a bank account and try to close out that bank account, they're going to ask me, how do I prove that I'm the executor? I'm going to pull out my short certificate and give it to them. So you need to probate a will if the client had assets in his or her name. So it sounds like from the question, it says, I leave my estate to my four children in equal shares. If your client had assets, if that person had assets in his or her own name, you would need to probate the will. So for example, if they had a house in their own name, $1 million brokerage account, you would need to probate the will, and then you collect those stocks, collect the cash, pay the debts and expenses of the estate, pay whatever inheritance tax and taxes, and then at the end of the administration period, you distribute it to the four beneficiaries. If the client didn't have anything in his own name that that passes under the will, you would not necessarily need to probate a will. So an example is, if a husband and wife own everything in joint names, their house, their bank account, their brokerage account, and Pennsylvania provides that when wife dies, everything automatically passes by operation of law to husband. When wife dies, you might not need to probate a will because there are no probate assets, right? Everything passes by operation of law to the surviving spouse.
Okay, thank you. And I have a question for Bernie now. I have the question, who should use a book like The Big List or a similar questionnaire, and when?
That's a great question. I'm happy to answer. So first of all, who uses a book like The Big List? Everybody. What if in my world, a musician is on the road who may get stuck somewhere, not able to come home, but the bills are due at the top of the month, needs to call his or her spouse and say, hey, open up the book, go to the page where it has the billing information for Pico and pay the electric bill. Or someone who's getting on in years and might not think they're going to survive, they can really help their executor. Someone who might be having some memory troubles, you want to preserve those memories beforehand. So everybody and anybody, young and old, could use a book like this. And it's really, really helpful to your executor and to your spouse or whoever you're putting in charge of your affairs. As far as when to do it, yesterday is when you should do it, because I like to say we plan and God laughs. We never know when something might happen. I was actually, unfortunately, a colleague of mine, a woman who's a music publisher in New York, in her 50s with 2 teenage children, got chest pains a couple of days ago and passed away suddenly, just like that. Now her poor family is going to be left scrambling, trying to figure out what to do with all of her affairs. If she had hopefully filled out a questionnaire like The Big List or something similar to it, that'll take a lot of the burden and stress off of that. So I encourage everybody, whether it's my book or anyone else's, to make sure you write this stuff down now. And one other tip I'll give you based on what Robert's been saying about your digital legacy. Sally and I keep a list of all of our passwords and usernames for the various websites we go to. My list, it's very, very fine print, but it's a dozen pages long now because there's at least 100 websites that I regularly use that I have to use passwords for, and I keep it updated. And I print it out once in a while and keep it in a safe drawer because it's, you don't want to have old information there. So I encourage you to make an alphabetical list of all the websites you go to, all the social network pages you use, with the address of the page and a column for the password and a column for the username, so that it becomes very easy for your executor to use that in addition to the questionnaire to get to all of your digital assets as well as your physical assets.
Wonderful. Thank you so much, Bernie. I do see a few more questions coming in. However, I know we are over time and we are going to move into the breakout rooms. Bernie and Robert will be filtering through all of the breakout rooms, so you'll have another opportunity to ask them your question directly. Also, a quick reminder, both CLE words have been given out at this point, and unfortunately, Villanova is unable to share them with you. So please stay on the call for another few seconds while we do the breakout rooms. If you do not plan on attending the breakout rooms, please sign off, and thank you so much for attending.